For roughly the last year, the Walt Disney Company has been engaged in a frivolous federal lawsuit against the state of Florida and Governor Ron DeSantis, along with the newly appointed Central Florida Tourism Oversight District. And just yesterday, the federal judge overseeing that case finally slammed the door shut on Disney for lack of standing because, well, we told you so.
RENEGADE Online.
Well, folks, welcome back. Another great day here at Valiant Renegade. It's good to see everybody out there once again. And if you are like one of the many folks watching this video, not yet subscribed to this channel, please take a moment and turn that little red subscribe button to gray. Hit that like button, hit that notification bell, share this sucker out on the social medias, and of course, please do leave a comment before you head out the door today. Make sure to join us every Sunday afternoon at 6 p.m. Eastern right here on Valiant Renegade for the live show. Well, surprise, surprise, or really maybe no surprise whatsoever, as a judge dismisses Disney's free speech lawsuit against Ron DeSantis. And we've been telling you about this since this thing was first filed. And again, since Disney amended their litany of claims that they had in federal court against the state of Florida, the Central Florida Tourism Oversight District, and yes, even Governor Ron DeSantis. They left just the free speech claim standing because, well, the rest of it was going to get held up in the state court case. That's the court case that was filed in retaliation by the Central Florida Tourism Oversight District against the Walt Disney Company, saying that, no, I'm sorry, the legislature and we have the right to do what we did. Disney decided to dismiss some of the claims that were matched up in the federal suit in order to give them a clear runway to claim that they had a First Amendment violation. And we've covered before why all of this was dead wrong to begin with, but let's read the article. Walt Disney Company's lawsuit against Florida's Republican Governor Ron DeSantis and others, alleging they retaliated against the company for publicly criticizing a controversial parents' rights education law backed by DeSantis, was dismissed by a federal judge on Wednesday. Judge Allen Winsor ruled that Disney lacked the legal standing to sue DeSantis. He added that Disney's charges, quote, fail on the merits against the members of the Florida Board of a special improvement district in which the company operates its parks and resorts. In his ruling, Winsor said that Disney, quote, has not alleged any specific actions the new board took or will take because of the governor's alleged control. He added the company, quote, has not alleged any specific injury from any board action. Quote, it's alleged injury. It's operating under a board it cannot control. That injury would exist whether or not the governor controlled the board, he wrote. Disney goes on to suggest that it will appeal Judge Windsor's ruling. And according to Disney, their statement is as follows. This is an important case with serious implications for the rule of law, and it will not end here, the company said in a statement. If left unchallenged, this would set a dangerous precedent and give license to states to weaponize their official powers to punish the expression of political viewpoints they disagree with. We are determined to press forward with our case. Back in April of 2022, the Walt Disney Company decided to pressure its CEO into getting involved in Florida politics, something that Bob Chapek, then CEO at the time, said very clearly that he didn't think Disney's place was being involved in such things. But nonetheless, he was pressured and forced to do so by certain elements inside Disney that were left behind as sabotage by Bob Iger. Not only did Disney oppose House Bill 1557, the Parental Rights in Education bill, but then went on to make statements that they would do everything in their power to coerce the legislature into repealing it. This, of course, drew the ire of the Florida state legislature, the massive, overwhelming majority of Florida voters that put them there, and yes, of course, Governor Ron DeSantis. Subsequently, the state of Florida and its legislature decided to undo the 1967 Reedy Creek Improvement Act that they put into place almost 50 years ago. In fact, that entire piece of legislation was almost entirely drafted unilaterally by the Walt Disney Company back then, telling the Florida state legislature to just go ahead and sign it. Now, of course, at the time, the legislature was more than happy to do that because it was going to put a big new theme park, bring lots of tourists into Central Florida, an area that had so far been undeveloped. But that district was afforded a massive amount of omnipotent power, something to date that no other municipality, no other special taxing district has since been afforded. And there's a good reason for that. No government would ever again be so stupid as to create this. But one of the things that was always critical is that because the legislature had created this special taxing district inside of its own borders in the state of Florida, it also always had the power to destroy it, or in the case of Florida's response in 2022, to reform the Reedy Creek Improvement District to the Central Florida Tourism Oversight District with a new board that would not be appointed by the Walt Disney Company, but in turn be appointed by the voters of Florida through their duly appointed and elected representatives and the governor. Of course, that drew Disney's ire. They filed lawsuits claiming their First Amendment rights had been violated. But as we continued to remind folks, what was always in fact since the very beginning, and the same reason why this case was ultimately going to be dismissed as it now has, is that the Reedy Creek Improvement District is not a right that the Walt Disney Company held. It was a privilege extended to it by the voters in the state of Florida. Furthermore, the Reedy Creek Improvement District and the special taxing district that it encompassed, guess what? It is not the Walt Disney Company. It is not a subsidiary of the Walt Disney Company. It's not owned by the Walt Disney Company. It's owned by the state of Florida and the people. Disney's outrageous claim was doomed from the start because the state of Florida did not retaliate against the Walt Disney Company for a political stance. The state of Florida simply exercised its constitutional right and authority over a special taxing district that it had previously created. In other words, to correct a mistake that was made in 1967 that never should have been. The other 2,000 or so special taxing districts in the state of Florida have been operating under an entirely different set of laws, Section 189 and 190 of Florida state statutes, than the Reedy Creek District and the Walt Disney Company had since 1967. It was time to put everything back onto a level playing field, and the Florida state legislature finally got the political willpower to correct that mistake. And to all the pixie dusters out there complaining that this judge was appointed by former President Donald J. Trump, well, sorry to tell you, but at least he understands how the law works. At least he understands how the Constitution works. At least he understands what the proper authority for the state of Florida is, governing its own municipalities and taxing districts. And let's go back one more time to Disney's response to the outcome. This is an important case with serious implications for the rule of law, and it will not end here. If left unchallenged, this would set a dangerous precedent and give license to states to weaponize their official powers to punish the expression of political viewpoints they disagree with. So hopefully after this video, you can look back at Disney's absurd response and understand why nothing that they said matters in this case. It is nothing more than a ridiculous gaslighting lie. Disney was not injured by anything the state of Florida did. They believe they had a right to abuse the voters, to abuse the state of Florida, and to abuse power and privilege over a special taxing district that was created by the legislature. All of Disney's fake cities and fake residents that they personally put in those little double-wide trailers in Bay Lake and Lake Buena Vista, people that were handed pieces of property by Disney with a promise that after their term on the board would end, let's say, that they would be forced by contract to turn that property inside the district back over to the Walt Disney Company. The whole thing was a sham. It was a scam. And it's typical run-of-the-mill behavior for what has become one of the most corrupt companies in the entertainment industry and possibly America. Sorry, Disney. You lost. The law won. Go home and cry about it, because the rest of us that know better just don't care.
Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.